Hello there. I'm attorney Kelly Longtin, and today I want to talk to you about what to do if you want to undo your revoked will. So, when life circumstances change, you may alter the decisions that you've made in your estate planning documents. You might choose to revoke your will at some point. But what if you have a change of heart and you want to later reinstate it? There are different ways to revive a revoked will, and that's what I'm going to talk to you about here today. Now, depending on your state law, you may have a few options when attempting to make a previously revoked will legally valid again. It involves either revoking the new will that revoked the old one, expressing your intent to revive the old will, or re-executing the original will that you have revoked. So let's talk about revoking a new will to reinstate the old one. Now, under common law, if a subsequent will revoked the original will, effectively revoking the second will could actually revive that original one. The most recent will is typically considered to replace any previously created wills until the most recent will becomes effective at death. Until then, the first will is not really revoked, but superseded by the later will. So tearing up or destroying the second will and any copies of it means that that first one can spring back to life and actually be the controlling document at your death. However, most states do not follow this rule, so reviving the old will likely will not be that easy. Now, some jurisdictions allow the revival of a revoked will if it is evident from the circumstances of the revocation that you intended to revive that first will. Will revocation and revival can be simplified by focusing on expressly stating your intent in the appropriate format and by following the necessary formalities for execution. Your intent to revive a revoked will could potentially be found within the new will that revokes any previous wills and restates and incorporates the terms of the will that you seek to reinstate. If indications or language within that revoking document suggest an intent to restate the original will, the court might consider this as evidence of revival. Alternatively, the mere destruction of the most recent will may serve as evidence of your intent. If this was your initial goal and you had an estate planning attorney conduct a careful analysis of the language used and the context in which the revoking document was created, you may be able to actually reinstate that first will. Now, another avenue for reviving a revoked will involves recreating that will. You must sign a copy of a new or identical will or execute a codicil, which is like an amendment, to the first will that expressly states your intention to revive the original will, effectively republishing it. This typically involves following the same legal formalities that are required for creating your first valid will, such as signing in the presence of witnesses and a notary, and meeting other legal requirements based on your state laws. The act of re-executing the revoked will through the use of a codicil should be accompanied by an express statement to indicate your intent to revive or reinstate the terms of the will that was revoked. Now, different states interpret and apply these methods differently, leading to variations in legal outcomes based on regional statutes and precedents. It is important to consult with an estate planning attorney to correctly revive a revoked will and ensure that your wishes are accurately represented and upheld. If you've created a will, revoked it, and would like to revive it, understand that you may not be able to tear up the new one and immediately revert back to that old version. Do not attempt to recreate or reinstate that will yourself. The interpretation of will revival and revocation laws can vary widely based on the state where you live and legal precedent. Wills are legal documents that must be validated in probate court after you pass away. If you have multiple drafts of your will, your intent is unclear, or they are not developed in compliance with state laws, the court may follow the state laws of intestacy instead of your wishes. Your beneficiaries may not receive their inheritance as you intended, adding to more disappointment and to their grief. Now, we can help you document your wishes if you live in Massachusetts and New Hampshire, to make sure that your will clearly states your true intentions. So we help clients every day, and we help play a crucial role in helping them develop their will and the rest of their estate planning documents. So I hope you benefited from different ways in which you can revoke and revive and put your intentions of where you want your things to go after you pass away, and make sure that they were clearly written and your intentions are clearly known. I want to thank you for watching. I'm attorney Kelly Longtin from Kelly Longtin Law.